My name is Joanna Barron. For those of you who don't know me, I'm Executive Director of the Canadian Constitution Foundation. And we're excited to present this town hall on free speech and the Jordan Peterson College of Psychologists matter. So we're going to get started. So good morning or good afternoon. My name is Joanna Barron. I'm Executive Director of the Canadian Constitution Foundation. And I'm here with Russell Phillips, our Director of Communication, Christine Van Gyn, our Litigation Director, as well as our special guest, George Avram, who is a partner at Baker McKenzie and who is the CCF's counsel in this matter. So just to give you an overview, I'm going to give a sort of brief high-level overview of this case and why we think it should interest you and why we certainly think it's important for Canada. Then I'm going to pass it over to really our expert and one of the leading legal experts in this matter, George Avram, who will talk about the CCF's position, what we call an intervention in this case. Then I will pass it over to Christine Van Gyn, who many of you know, the face and creator behind CCF's YouTube channel, who will sort of engage in a dialogue with George. And then we're going to turn to first questions from CCF's Freedom Insiders. So for those of you who don't know, Freedom Insiders is our private community for CCF donors, and it can be donors of any amount. And Russell, maybe you can put a link in the chat a few times throughout this town hall to let people know how they can become a Freedom Insider. So first of all, if you're a Freedom Insider in future events, you will be exclusively invited to these town halls. We did want to open this town hall up to the public because of the unprecedented public interest in this case, in this Jordan Peterson matter. But you also can pose specific questions to be privately recorded and answered by Christine and I. So we record almost like a little private podcast every month, and lots of other things. So we'll address the Freedom Insider questions first, and then we'll have some time for questions from everyone. So what is this Jordan Peterson versus College of Psychologists matter all about? So this dates back to complaints that were lodged in 2021 and 2022 by members of the public who really just tweeted at the Ontario College of Psychologists complaining about certain of Dr. Jordan Peterson's tweets and public statements. And the College of Psychologists, which is the regulatory body that regulates all practicing psychologists in the province, found these statements unprofessional, and we can kind of get into later what the statements were. But the important thing to note was that they did not relate to the practice of psychology. Those of you who know Dr. Peterson know that he's an outspoken critic of various aspects of Canadian culture and politics. And the college found that they were unprofessional in connection with the practice of psychology in Ontario, meaning that they threatened a risk to the reputation of the practice of psychology in Ontario, and they ordered him to participate in a remedial coaching program, which he has called a re-education program. And Dr. Peterson, of course, challenged this decision, arguing, amongst other things that we'll get into, that the college didn't balance his charter-protected right to free expression with the college's own objectives, which, of course, and Christine will talk about this, the college does have certain objectives, and that's proper as a self-regulating profession empowered by a statute. However, our interest in this matter is really about free expression. Free expression and the right to free speech is one of our priorities as an organization. And for us, this is both valuable for individuals so that individually we can self-realize, we can express our views, but also for society. Right? It underpins what we would call the search for truth and helps buttress democracy, because we can't have a strong democracy unless as individuals we're well informed. And in terms of professionals, so one thing that you'll hear time and time again over this hour is that this is not really about Jordan Peterson. Jordan Peterson has a full career as a sort of public figure, public intellectual at this point. He does not rely on the practice of psychology to pay his bills. But there are millions of professionals in this country. And by the way, this case also got the attention of some publications in the United States, because they also see echoes of this. This is about any professional that is regulated. So nurses, doctors, lawyers, psychologists, many others. And our position is that the public has a pressing need to hear critical perspectives, not just perspectives that affirm the status quo from those in society who have professional training, who are valuable members of a democracy, not just because of their particular training as nurses or as doctors, but also just as citizens. And so if we set a precedent that says if you're a member of a regulated profession, you can't say anything that could skirt the edges of being controversial, we have a real problem, right? And I want to briefly, just to wrap up my introductory comments, mention that this is an area that the CCF has a proud track record in. We were interveners in a case a few years ago called Strom, which was a matter of a nurse in Saskatchewan named Carolyn Strom, who made some critical comments on Facebook about her father's elder care. We know elder care is a big problem in this country, and was reprimanded by her own regulatory college, her own nurses college, for those comments. And that decision was overturned by the Saskatchewan Court of Appeal. And I'll just read a short passage from that decision from Carolyn Strom. The court found that just because a regulatory college has a certain mandate does not mean that the entire life of a professional should be subject to inordinate scrutiny on the basis of more ordinary standards of behavior, since that would lead to a substantial invasion of the privacy rights and fundamental freedoms of professionals. And so the case is very similar in the case of Jordan Peterson and anybody else who is under a regulatory profession in Canada. So this is not just about him. This is about our rights as individuals and recognizing that we wear different hats as members of society. So with that, I will turn it over to George. Hold on, I'm going to pin you and remove my pin. George Avram is a partner at Baker McKenzie, and he's been proudly our counsel in this matter. So he's going to talk about the CCF's intervention and talk about the arguments we made, and then I'll turn it over to Christine.
Thanks, John. Hi, everybody. It's a pleasure to be here and to join you. When we started talking about what our position would be, we had to really think carefully about how we would be different, candidly, than other interveners. And our focus, when you sort of peel the onion back, was on liberty interests. And it was on liberty interests in two respects. One, how far can a regulator go in to regulate what we would call off-duty conduct? What is the nexus that is sufficient for a regulator to go in and candidly intrude into people's private lives? That's the first part. And then the second part is that liberty interest is amplified when you are dealing with freedom of expression. So the case law on all of this has been pretty clear, which is you look at the clear nexus. If there's a clear nexus, taking into account the charter right, then you go into a balancing interest between the regulator's interest and the individual's interest in their charter right. That was, as Christine knows, getting very conflated at the hearing of this matter. And I think where CCF really added a lot of value is to sort of zoom back and sort of really articulate there's two parts to this. There's two different thought processes, two different tests, or two different parts to the test that you need to look at. And the first is you don't even get to the balancing interest of the charter until the regulator establishes it has a legitimate interest in regulating the conduct. So in Dr. Peterson's case, they said his tone was inappropriate, and some of his comments vis-a-vis the trans community were inappropriate. And, in and of itself, I guess reasonable people can disagree about whether his comments were or were not appropriate, but that's not really the question. The question is, why does a regulator care? And why did the regulator care here, or they said they cared? Largely, if not exclusively, because he had clinical psychologist in his Twitter handle, and two, because on the Joe Rogan podcast where he made some comments, largely about the environment, by the way, he identified himself as a clinical psychologist, and the introduction of the program, the podcast, he was introduced as a clinical psychologist. That's it. And when you look at the reasons for the review committee, that was it. There was more they could have said, but they didn't. So back to Joanna's point, where I think our position was pretty clear, was that's not enough, right? You look at a whole range of professions and you look at whether it is sufficient to regulate somebody because they've identified themselves, as in Strom's case, a nurse. She was clear she was a nurse. And when they disciplined her, but when it went to the Court of Appeal, it said, no, that's your one-dimensional focus. You have to look at broader factors. How is it what she said have an impact on her and how she can engage in the profession? And they had no answer. I mean, that was, I think, pretty clear. And the CCF did a wonderful job in that case, articulating that position along with Strom's counsel. So you can't look at this, in the words of the court, in a one-dimensional matter. And in Strom's case, like in Peterson's case, there was a lot of discussion and submissions on the free expression right, because what Strom was saying and what Peterson's counsel was saying here, and we were supported by the CCF, is that what he is saying and what she said actually adds to the public discourse. And that is really what's key here in terms of free expression. So don't get into the balancing of the regulator's interest versus the interest of the individual in the charter protection, because you don't get there. That person, even though they're a professional, still has a right to free expression. And that has to somehow be linked to the interest of the profession, which is to protect the public. And remember, Dr. Peterson hadn't practiced clinical psychology since, I think, 2018. So again, identifying himself as a clinical psychologist was one factor, and the court's going to have to look at that, right? Because I think that's clear, but it can't only look at that. And I know we'll talk a bit about some of the deficiencies in the approach of the review committee in trying to deal with him, but their core issue was they didn't like his tone. But I don't know. I mean, I read those free expression cases out of the Supreme Court of Canada. Tone is protected as much as content. And you know, let's remind ourselves. I know everybody here knows this well. What kind of speech is in need of protection? It is the unpopular speech. It is the bad speech. It's not the speech everybody agrees with. I mean, that's the old Soviet Union. Some would say current Russia. That's easy. That's easy speech to protect. So that was really the core interest of the CCF. And we gave examples of accountants and teachers and how the regulators in those cases said, it's not enough for her to be a teacher. She's also a mom. So when she goes in to speak, for example, about her kids and the concerns that she has about how her kids are being taught, don't tell her she has to use the code of conduct proceedings articulated by the particular school board. She's not acting in her capacity as a teacher. She's acting in her capacity as a parent. So let's not try and cast a broad net over these folks. And I think that was the core. I think we've made that clear. There was one judge in particular who was pretty hot about the Dr. Peterson identifying himself as a clinical psychologist before we get up. And I think we deflated that, quite frankly, by relying largely on Strom and the good work that CCF did in that case. Joanna, Christina, I don't know if there's anything else you'd like me to add on that point, but I think I'll stop there and turn it over to Christine.
That's great. Thank you so much, George. I don't know if Joanna, if you can pin me to to the front right now.
I have
But
you, which should be good.
okay, great. Thanks. I apologize. I'm doing this from my phone. I'm having a problem with my computer. So thank you so much for that, George. And thank you so much for your advocacy in this case. It was so thrilling to watch lawyers at a really high level doing this case, even though I obviously disagreed with the position that the College of Psychologists was taking. I think it was a really fascinating hearing to be observing. So what I wanted to do was go through some questions to lay out some of the principles that really came up in the hearing a few weeks ago and get into answering some of those. And we're then, when I'm done these questions, Joanna's going to pose the questions from our Freedom Insiders. And if any of you who are watching right now have your own questions, please leave them in the Q&A tab, and we're going to get to those at the end. And if you want your questions prioritized next time, of course, you can become a Freedom Insider by clicking on that link that Joanna shared in the chat below. So a big part of what we spent time at the hearing about, George, was about the adequacy or inadequacy of the reasons that the college gave for ordering this training for Dr. Peterson. And Dr. Peterson was arguing that the reasons were inadequate. The college was arguing sort of the opposite, that the reasons were good enough. So part of what the decision may come down to might be that question about the reasons for the retraining. What can you tell me about why Dr. Peterson's lawyers were arguing why they were inadequate? What exactly was the deficiency in the reasons? And what can you add to that, and why that might be the crux of this case?
Yeah, I mean, where to begin, right? I mean, Dr. Peterson's actually counsel were excellent. So everybody knows they did a wonderful job on his behalf. But let me start with what, the CCF is mostly interested in, which is, of course, the charter right that was engaged. And the entire analysis, and I wish I was making this up, but I'm not, on the charter issue and these reasons, and I'm reading this now. While the panel recognizes Dr. Peterson's constitutional right to freedom of expression, as a member of the College of Psychologists, he is also obligated to maintain the professional standards of the college. That was it. That's the entire analysis of his charter rights in terms of the nexus between his off-duty conduct, what they claimed was off-duty conduct, and the regulators' interests. And that was it. That was the entire analysis. And Dr. Peterson's counsel certainly was very effective in pointing out that that's just not an analysis of Dr. Peterson's freedom of expression rights. That's just a boilerplate saying he has the right. Well, I don't even know they needed to put that in, because we all seem to have that right. Last I looked, right? I mean, so that was woefully deficient in terms of the reasons. I think the second thing I would say about the reasons is they identified the offending conduct, but then didn't analyze anything, right? So he identifies himself as, of course, as a clinical psychologist, and that was a big issue. They then deal with some tweets where he called Catherine McKenney, whose pronouns are they, them, an appalling, self-righteous, moralizing thing. And then, in terms of Elliot Page, that he intentionally addresses Elliot Page, who preferred to go by him as her, and by their former name. But that's it. Like, there's no reason there's no link then as to how those tweets or those comments impact his profession, right? Then they quote their code of ethics, but there's no linkage, right? I'm not trying to be sort of, okay, this is what a judge would do, because this is sort of a lay body. but there's got to be more to this, right? It's just declaratory statements and say, we don't like it and no more. And everybody should know this wasn't the first time this committee made a decision about him. There were other decisions, and they said, okay, well, maybe your tone is off, but we don't think it's an issue. They weren't really that dissimilar, the tweets or the comments. So at least some, including me, quite frankly, could draw the inference that they just had enough of dealing with the public and not the public outcry, a few people forwarding the tweets or retweeting to the college about what he was saying, that they figured they had to do something. But I mean, that's the analysis, and I think that's a biggest flaw or a big flaw in the college's case.
So I think that leads to a follow-up question, which is, obviously we have argued that there needs to be a nexus between the speech and the profession. And at that stage of considering the nexus, you also need to consider the right to freedom of expression. And the college didn't, right? As you said, they basically just said, we know that Dr. Peterson has a charter right, moving on. That was it. And in our view, that's not sufficient. But if, in this case, we don't think there is a nexus, but say there is a nexus between the profession and the comments, what kinds of things could the regulator do or say to show that they actually had given sufficient weight to a charter right? I mean, we obviously argue there's no nexus here, but if there was, what would have made the reasons good enough? Obviously, just what they said, if you have a charter right and we're now going to ignore it, is not enough. But how could they have met that criteria that we think is necessary?
Yeah, it's a good question, Christine, because if I step back, I mean, the three of us, don't know about Russell, but Joanna, you and me are all part of a regulated profession, right? And we have free expression rights, of course, but there are probably certain things that we can't say or that we say could get us into trouble, right? Look at that case, the Justice of the Peace out of the Court of Appeal. It's a powerful decision. It's called Lauzon. I know I'm not getting that name right, but it's Justice Lowers in the majority, and she made some really highly critical comments about the penal system, and I'll just use that just generally. And while they overturned sort of the kicking her out as JP, there was still some nexus there to be able to sort of regulate some of her conduct, right? In this case, it would have seemed to me that what they had to do was to say, you're a clinical psychologist, you're putting this out there as a clinical psychologist because you say you're a clinical psychologist. And what's happening is, and the college didn't do this, but there's a letter, and it's in the record, this part was pretty clear, where Dr. Peterson said in his own letter, and it was his previous counsel, I've helped millions of people on Twitter by what I'm saying. Well, you're kind of getting closer to that clinical psychologist. If you're helping millions of people, you could be hurting some people, right? Like, I mean, I think that could have been fleshed out more. The material was there, they didn't flesh it out, right? So he would still have that free expression right. But once you're getting closer to that line of that profession, I think it gets a bit more challenging, and it was just deficient. There was a trans community intervener, as you know, Christine, in this case, and they said, look, what happens when he makes such comments is that it actually has a psychologically adverse impact on the community. And as a clinical psychologist, he should know that. Now, I think they were going outside of the record and making those comments, and I don't think the court's going to accept them. But those are the kind of reasons, if the panel thought about it, and actually, candidly, was a bit more diligent, could have included in this, right? So I think there had to be more sufficient reasons. I gave the example, and it's in our factum, about the accountant, right, who, as part of a condo board, and she wasn't getting what she wanted. and threatened and using her designation as leverage to report them to workers' compensation and to the CRA. Sure, she has the free expression to do that, but she's using her CA designation as leverage there, right? So there, in that case, there was clearly reasons putting that linkage together, explaining, yes, you have free expression rights, but once you start using your designation as leverage, you sort of now bring that nexus closer together between the regulator's interests and the off-duty conduct.
Yeah, so let's talk about that, the nexus, but first, I on the comment on the trans organization and LGBTQ advocacy organization intervener, is the same intervener. If they're going to make an argument that there's harm being caused, like obviously they have to lead evidence that there's harm being caused, and as an intervener, you are not able to lead evidence. So there's a big problem with interveners like that, and when we intervene, are very careful not to do that. Because you can get reprimanded by the court for doing that. So let's talk about the nexus. A lot of attention has been paid in the hearing and generally to the fact that Dr. Peterson's Twitter bio says that he is a psychologist, and he was introduced on the Rogan podcast as a clinical psychologist. He is a clinical psychologist, is well known that he is. But when he made these comments that led to this, I guess, non-disciplinary disciplinary action, he didn't say them as a psychologist, I think Jerry Butts is a prick, or as a psychologist, I think that this swimsuit model is not beautiful, or whatever it was he said there. He didn't make these statements couching it in his role as a psychologist. So what exactly, it's just known that he's a psychologist. So what exactly would be enough to establish that nexus between the speech and the profession? And surely it needs to be greater than just speaking in general as a psychologist, right? What would be enough to create the nexus?
Yeah, so it's a good question. So, like, again, let me step back. I mean, it's not a secret who Jordan Peterson is, right? I mean, so when the courts say, don't be one-dimensional in your analysis. Don't look at simply because somebody's designating themselves as a nurse or a clinical psychologist. It's just not enough because it's one-dimensional. You have to look at the context. And the context in Jordan Peterson's case is, I don't know, he's published 15, 20, I don't know how many books he's out there. He's a public intellectual. Everybody knows him. Which hat is he wearing? Is he really wearing the psychologist hat, or is he really wearing sort of the public intellectual hat? And, you know, so I think that's the first thing. But your second point, Christine, if he said, look, I've seen thousands of patients throughout my career, and I know, and I think this is his view, that, you know, when you're dealing with trans people, go to the underlying issues, because my experience dictates that the underlying issues is most people have mental health issues, and you're not dealing with the mental health issues, but instead are, you know, offering these therapies at a very young age. And I think that's his position. I'm articulating his position, not necessarily mine. So I think if he's putting out his experience, what he's seen, and in the sense of as a psychologist, the patients and he's seen, like not specifically individuals, but based on his experience, I think your nexus gets closer, right? Now, to be fair, that's not what he's doing. That's not what he has done. His comments about mental health were, it could be as much about his academic work, right, as about his clinical practice. But I think he's been very careful to avoid sort of getting right into any of that, with one exception, which is when, you know, he was falsely accused back in 2018 by a patient who accused him of sexual improprieties, if I might just use that term, and it was found to be false. There was no basis to it. And let me underscore that there was no basis to it. But what happened was he went on, you know, on Rogan and sort of said it was a pack of lies, right? And, the college tried to say, well, you don't have the right to do that because you're talking about a former patient, right? Is that closer? Maybe, but the answer back is, well, wait a second. I was exonerated. This went out into the public sphere about these allegations. Why can't I say in response, it was a pack of lies, right? But to sum it up, I think if he's leaning on his experience as a clinical psychologist and then giving an opinion on Twitter, on Joe Rogan and everything else, I think that brings it closer to an interest that the college may have in regulating. Again, you'd have to look at what he's saying more broadly, but I think that's where that line gets a little more blurry.
Okay, this is the last question from me, and we should try to keep this one brief because we want to get to the questions from our insiders and from the public. But the college has said that this is not disciplinary action. This is a preliminary stage, that they have not ordered any, there's no finding of professional misconduct. They are just ordering training, media professionalism training. What do you make of that claim by the college? And by Dr. Peterson's view, he has said here that the process is the punishment. So is this, even if the college isn't calling it disciplinary, what's your view of that? And what's your view of Dr. Peterson's response to that?
Yeah, so I mean, again, the first part is there still has to be a nexus, right? I mean, so I go back to this, like the law society can't order me to go get coaching if it's not something that's related to what I'm doing, right? So I think that's the first thing. I mean, the second thing is there's a coach here that's being inserted into this relationship that has a lot of discretion to report back to the college as to whether Dr. Peterson has successfully completed this remedial program. And what's left open is, well, what if he doesn't successfully complete it according to the coach's opinion, or doesn't complete it? Is it disciplinary afterwards? And the college wouldn't take a position on that, right? The college's position was, well, we don't know yet, right? I mean, I think it's cute, if I may use that, sophisticated legal term, to say it's not disciplinary, because it isn't disciplinary, but you've got a big sword hanging over your head if you're not really complying with the coach's direction, or you're not pleasing the coach who has a lot of discretion.
And who you're paying for an indeterminate amount of time.
Right.
It's his own expense. So that's the questions that we got through from me. I want to turn now to Joanna, who's going to ask the questions that have been sent in from our Freedom Insiders. And again, if you want to become a Freedom Insider for our next town hall, you can go to the chat and Joanna has a link on how to become an insider. So Joanna?
Great. Yeah. So I'll turn to the Freedom Insider questions, which are going to come up first, because these are people who have shown their support by making a donation of any amount at any point, which we really appreciate. I also would add that we take these cases because they are protective of your charter rights as Canadians. And the only way that we can do it is through private support. It's always funny to me how people ask me if CCF gets government support. And it's like, no, absolutely not. We sue the government. We don't get any funding from the government. We're funded exclusively by private individuals such as yourselves who have an interest in upholding your charter rights for yourself and for the generations to come. So with that, we have a few really interesting questions. And by the way, I see that some questions are coming in on the Q&A tab. So also feel free to share your questions there as we go, and we'll turn to them after the Freedom Insiders questions. So the first question is from Liz. I'm not sure if Liz is on the call, but Liz had a few very thoughtful questions. Her first question was, what future actions may we, the public, take to impact this canceling, silencing of opinions through regulatory capture in healthcare? Any thoughts on that, George? I think one thing is by suing the bastards like we're doing, nipping at their heels.
Yeah, I mean, look, I think that is absolutely the right approach first and foremost. Look, the other part is, and I'm not going to get into these law society venture elections because I had enough of them, quite frankly, when they were going on with all the emails. But I mean, these are self-governing professions, right? These aren't, and most of them are elected people. So there are there are ways, democratic ways, quite frankly, to ensure that, people that are in these professions are ensuring that people who get into the professions, don't have campaigns that overextend the regulatory reach. I mean, I think those are the two most prominent ways I can think of, Joanna. I mean, I think CCF's done, like I said, with Strom in this case, has done a wonderful job getting involved. You need, you need more Petersons to be able to challenge on judicial review some of the conduct here. Candidly, I think the college just gave in here to the public pressure.
Litigation is really where the rubber hits the road, right? Like, certainly as members of the public, your awareness, your support, but this is where we actually go and a binding decision will be made.
Yeah. I mean, so those are the two things I would say people can be active in and look forward to. I mean, I think it's I'm trying to sort of be objective here. I don't think it's in anybody's interest for the government to be running these professions, quite frankly. I think it's still better served that it's a self-regulated body that's overseeing itself. That causes some challenges, but I think you also have more control over it.
Yeah, and just to make it clear, for those of you who are not lawyers, yes, the government does things directly that affect our liberties, that clamp down on our freedom of speech, but increasingly in modern bureaucratic societies, we see the biggest infringements on these sort of intermediary bodies, right? So like regulators, administrative tribunals. And so that's why this is a really important area to stay active in, where it's not quite as directly as like the Trudeau government passing on constitutional law, but in a way it goes even more into the minutiae and weeds of how we live our lives on an everyday basis. Okay, I am going to, well, this is an interesting question from Joshua, and then I have another question from Liz. Joshua, with Canada becoming as corrupt as it is, what was the ultimate purpose in attending the trial and opposing the board of psychologists? Why not let the board revoke Peterson's license and advise him to strengthen ties with other practitioners who practice with integrity? So I have some thoughts on this. I don't know if, George, you have some thoughts. The bottom line is that this is not about Peterson, as we've mentioned, right?
Yeah, look, Joshua, I mean, you and I may differ on how corrupt Canada is, and leaving aside our differences there, I would say government and regulators have always been in the business of overreach. That's why this organization candidly exists, because it's meant to make sure that our freedoms are protected and that their government stays within the bounds of what we would call, well, not what we would call our constitutional framework, right? So I think the important part, at least for CCF, in this intervention, was not at all about Peterson. In fact, look, I don't agree with a lot of what he said, but it doesn't matter what I think, right? I mean, free speech is there to be protected for obnoxious speech. It's not there to protect the popular speech or what's most favorable right now in this moment. So I think our position, and CCF, Christine and Joanna can speak for themselves, was we're just not going to let them get away with just unchallenged regulatory power when it's something this tenuous involving his profession, but the importance of free expression being out there, right?
Yeah, I totally agree. Okay, this is another question from Liz. How can we regain freedom of choice with a preferred healthcare practitioner when many of them are being censored? Well, hopefully through carving out appropriate protections through precedents like this, precedents like Strom. Any other thoughts, George?
No, I mean, I agree with you, Joanne. I think we have to just keep our foot on their necks, as they would say, right? We just can't let that overreach continue. And, in my other, when I do my private practice, right? I mean, I do a fair bit of management side labor and employment work, which, and what I do is what we, tell our clients is stay within your lanes, right? Like, don't try and again, on off-duty conduct, try and go out there and regulate people's private lives. So I think the approach CCF takes and making sure that they are as active as they are, and we are actually, because I'm a donor. I'd be asking the questions here if I was on the other side. I think it's an important organization, and as much as has been said, we were aligned with the CCLA in this case. Like, we were on the same side. So all the nonsense being spewed at times on Twitter and everybody else, don't let them fool you. Don't let them get you agitated. There are a lot of people who and organizations who really press for liberty and who are prepared to advocate for such. So I would continue encouraging CCF to do the same.
Yeah, we're actually the silent majority. Okay, one more Freedom Insider question that I can answer, and then George, you may have some comments. Wondering if, this is from Paul, wondering if anyone from CCF has been in contact with Jordan Peterson or his legal team If so, how has he or they responded to your intervention? So I actually bumped into Dr. Peterson at a fundraising dinner a week or two ago, and I spoke to him about our intervention, and he was very grateful. And he even tweeted out some of Christine's videos summarizing the hearing. So some of you may have come to us from that tweet. If so, welcome. This is what we do all the time, not just for Jordan Peterson, but we take these liberty cases all the time. But he was very grateful. He also has a brilliant lawyer, Mr. Hennon, Peter Hennon, that we've worked with closely. And George, you would be better positioned to comment on that.
Yeah, no, they fully supported our intervention. We worked closely with them, recognizing they were a party and we were an intervener and we had a particular role in this case. But they embraced it, they welcomed it, and we're really pleased with our materials and our submissions to the court.
Okay, great. So I'm going to bring on Christine, who's going to pose to George in our remaining 17 minutes questions from the Q&A tab. And if you have any, you can add them in. So I'm just pinned. There we go.
Thanks, Joanna. There's some really great questions in the Q&A here. The first one of them is a question I didn't get to that I wanted to pose to George, that was about the college's fear or concern over their reputation, the reputation of the profession. And that's one of the things that they were saying, that this type of speech could bring the profession into disrepute, that it could suffer damage. And the question is, how can that actually prove it in some practical way? Isn't this notion of bringing the profession into disrepute sort of a subjective question? How do you actually see if damage was really done? And that's a question from Mitchell.
Yeah, no, that's a great question. And I think if I'm the college, I would answer it this way. Look at the people retweeting and tweeting Dr. Peterson's comments to us and telling us this is an embarrassment to the college, right? There's the core of your evidence. Whether that's enough, who knows? I mean, it's a different standard. This isn't a defamation type case where the proof on the adverse impact on somebody's reputation is more onerous. But I think in this case, given that they have complaints, remember, not from patients, because he's not seeing anybody, but from members of the public who are then tweeting or retweeting, is probably sufficient if there's a nexus, right? I mean, I'm keep going back to that. If there's a nexus to between what he's saying and the off-duty conduct and the profession.
So another question, I'll just answer this myself. It's from Quentin, who wants to know if the factum from the CCF is available. If you sign up for our email list, our Freedom Update email list at the ccf.ca/freedom updates. Just go on our website and sign up for it. I will send an email to our supporters who are interested in reviewing our factum. I do not believe that it's available on the court website, but I would be happy to send it out if there's interest. So here's a question from Jerry George, and it's: do these colleges or professional regulators, are they subject to, time limits for these professional proceedings? Do they have a responsibility to decide these issues within a reasonable time frame? And he says that a lot of professionals are dragged across time over complaints. So what's your view on that? Are there obligations on colleges, these administrative bodies, to decide these in a reasonable amount of time, these professional cases?
Yeah, so let's break this down into two, right? The first is there sort of a limitation period, if I use that term, for somebody to file a complaint as against a professional? Like, say these complaints were from 2010 or 2012. I think each statute that governs the profession would dictate the limitation period, but there's also common law and equitable principles of delay and latches, which would arguably say that you can't be putting a professional through something that happened 10 years ago when their memories are faded, witnesses have gone or disappeared or died, documents that were on paper are no longer on paper. So there's all those equitable principles as well. I mean, you'd have to look at each statute to say to see what precisely the time limit would be if there's one. In terms of when after the complaint's filed, if you assume the complaint was filed within a reasonable period of time or within the statutory limitation period, then really it's really hard to get rid of an administrative law proceeding for delay. It's not like the criminal courts where a case called Jordan, where the courts are now throwing out cases because of undue delay, because that's specifically a charter right to have something done expeditiously in terms of a criminal trial. That is a dog's breakfast in the administrative tribunal process. I've got like the dreaded Human Rights Tribunal of Ontario. I've got a client who's had two cases there from 2010 and 2014 that are going nowhere. Right. So is it fair? No. Have witnesses died? Yes. Is there a way to get that kicked out so easily? No. And it's no different for somebody subject to a complaint under the Regulated Health Professions Act or equivalent statute in other provinces.
Sounds so frustrating. So there's two questions that are sort of related. One is from Lauren and one is from Patricia. And Lauren's question is, what would be the implication if the college wins? And then Patricia asks, is the government trying to set a precedent so that other regulatory boards in Canada can do the same thing to their members?
Yeah, so I suspect if the college, so there are a few avenues here, right? The easy way, candidly, the court dispose of this is to say the reasons are insufficient, go back and do it right next time. Review committee, right? And they go back, and what happens here is they get a good lawyer and they gussy up the reasons and they give these reasons again, and then it becomes more defensible on judicial review. If that's not what the court does and the college wins, I suspect Dr. Peterson seeks leave to appeal to the Court of Appeal, and he'll take this, I think, as far as he needs to. As far as he wants to, but he has said, I don't care, I'll give up my license. So I don't know which way he'd go. I am concerned about a finding where on this record, the nexus is sufficient to regulate a professional, and I am concerned about the precedent it sets if Dr. Peterson does not seek leave to appeal in these cases, for sure. In terms of your other question. I know Joanna made this point earlier, right? This isn't necessarily the government doing this, right? It's a regulator created by statute. So they're not really you couldn't challenge their actions directly on the basis of the charter where you could do that for any government action. It's a bit different. And I think what you could do is deal with what you can through your legislatures. And I saw some comments here in the Q&A. In some provinces they get appointed, right? So you have to look at how you deal with that situation where they are appointed, and if there's any avenues within that regulated profession to change that or to influence that.
Okay, here's a question from Neil, and this sort of relates to my first question, which was about whether or not the reasons provided by the college ordering this retraining, if those reasons were sufficient. So Neil asks, if the court does quash the college's decision, does the college have the ability to reopen the investigation and this time maybe provide better reasons? Or does that mean that this case is decided?
That's a great question, because I think the answer, as any lawyer would tell you, is it depends. So on the one hand, if they quash it and say it's quashed for insufficient reasons, they can't reopen it, right? It's done. It's gone. Now, remember, on judicial review, there are a lot of discretion on the remedies that can be awarded. They could also say, well, we can't figure out what the reasons are. Go back and tell us what the proper reasons are. And then Dr. Peterson figure out if you're still going to challenge it. And then that's the second scenario, which is then they sort of come up with more robust reasons and make it more bulletproof such that it would survive on a judicial review.
So we have a question now from Ken, and Ken says, I am an education professor. Teachers have historically been viewed as teachers 24/7, especially with respect to public behavior and speech. Do you see any move in society away from such a strict standard?
Well, this is a case we relied on quite heavily, actually, in it's called Egerston versus Alberta Teachers Association. It's out of the Alberta Court of Appeal. It's an older case. It's 2002, but that was the case where I think I referenced earlier, where the teacher had concerns about how her children were being taught, and took it upon herself, as any parent would, to address some of those concerns. The regulator then said, no, you can't do that. You have to exercise your speech, because that's really what it is, right? Through the process we have for teachers. And the Alberta Court of Appeal said, no, you don't. I mean, that's just not right. This person is a parent, is exercising her right to speak to her kids' teachers through a process that any other parent has. You're not limited to being able to go and force her to go in a particular way. I mean, the other thing I would say is, you go back to that old case, Supreme Court of Canada in Ross, right, where the teacher was making the anti-Semitic remarks. And Justice Corey in that case goes out of his way to say not every comment the teacher would make would necessarily lead to punishment. But here, given the anti-Semitic remarks, it poisoned the teaching environment, right? Because it became public. So that's kind of the difference, I would say. I don't think it's as broad and as sweeping as the questioner suggests. That said, it's like lawyers, right? Lawyers go out, and if and it's different than expression, but if you go out and commit fraud, it has nothing to do with you're practicing law, you're probably not going to have a license, right? Because it's so intertwined with your profession that it's not, no court is going to say that that's off-duty conduct and therefore the penalty is too severe.
So we've got another question from Manon, and he says, hi, George. In the case of free speech from professionals who are speaking outside their practice, it strikes me that regulatory bodies seem to enforce the principle of one law for me and one law for thee. They often encourage left-leaning members of the profession to say anything they want, but they punish dissenting views. Is there a breach in their duty of impartiality with respect to these different viewpoints of speech?
Yeah, I mean, look, let's take this case, let's ground it in these facts, right, with Peterson. So if Peterson's counsel had information or had evidence that that was going on, another psychologist saying Christians are all nuts, right? Or a bit, or making anti-Semitic comments, and that person was treated differently. Then I think on this record, on this judicial review, that would be fair game evidence, and you'd have to bring in probably a fresh evidence motion, or if it's a public decision and they didn't do anything, you can bring that over and just argue the inconsistency and the arbitrariness of it. I think that's the only way you can really ground it in something, anchor it in something. Otherwise, the court's just going to say you're just speculating.
So we have a question from Ted about the distinction between the government and the regulator, because we've explained that this regulator is established by legislation. So it's not as if, it's the Ford government doing this, but they are empowered through legislation. But Ted says, I want to make the point that certain regulators, and he gives the example of the CPSO, which is the physician regulator, maybe you could argue is an arm of the government, because counsel for the CPSO is mostly appointed by the government. So he says that they are really not self-regulating, that it is basically acting as an arm of the government. What's your view on that?
Yeah, look, I think you can, that differs province to province. Universities differ province to province. So in Alberta and Manitoba, for example, given the amount of government control over universities, they have been found to be state actors. And in one case, specifically for free expression purposes, right? So in Ontario, they haven't, right? So I guess it really comes down to how much you can prove that they are actually a state actor. And then again, what value does that bring to the analysis, right? Because you're still dealing with, even if they're a state actor, you're going to have to launch an application, a charter challenge. You're going to have to claim your 2B rights. And then the government's still going to have the right under Section 1 to sort of say, this is justifiable because, why? Because there's a nexus between what you are saying and the profession, and therefore this is minimally impairing and can be saved. So I hear what you're saying in theory. I just don't know practically if it makes a difference on the ground in terms of litigating these cases.
Okay, the last question is from Steve, and he asks, how does this case relate to other active or recent cases brought forward about freedom of expression? And I'd start by hyping ourselves, because we've been involved in a number of these cases. The two that really come to mind that were cited in this hearing were the Strom case, which was about the nurse who was sanctioned by her regulator, the nursing regulator in Saskatchewan, for public comments she made about the care her grandfather received. And the other case is the case of Mike Ward, which was a Quebec case about a comedian who made some jokes about a young boy with a disability that the audience laughed at, but which other people think were distasteful. And he was sanctioned by the Human Rights Commission, brought a claim against him on behalf of this boy, and he was given a fine, a penalty. So anything you want to add to that, George, to any of the interesting recent freedom of expression cases that related to this case?
No, I think CCF's done a great job making sure that they're front and center in these cases. Look, I get a little worried about where this is going. I'm not going to lie to you. Ward was a 5-4 decision. It's in no way this should be a 5-4 decision. Now, Justice Abella retired, Justice Brown left the bench. You've got changes. I don't know where this goes. So I think you can't rest on the good results that CCF has secured. I think, like I said, done a wonderful job. But I don't think this thing is settled. You've got a different Supreme Court now than you had 6 months ago, 8 months ago, certainly since Ward. And, you know, and with war being a 5-4 decision, you just can't rest on that being the law going forward.
Well, George, thank you so much for coming to talk to people about this. We had about 90 people who were listening throughout this entire video, the live stream, and we're going to put this up onto YouTube so people who weren't able to watch live can watch it. I appreciate you so much, George, for the work that you've done on this case and all our other cases, and for your commitment to the values that we stand for at the CCF. It's so great to work with lawyers like you. So thanks so much for everything you do for us. We really appreciate it. And thank you to everybody who watched the video today. Joanna, anything you want to add in closing out?
Just saying thank you. Thank you for coming with your questions. Thank you for your attention. We don't take it for granted. And please join us at the ccf.ca/freedom-insiders, or at very least sign up for Freedom Updates, because we have a lot coming up and a lot to announce to you. And we love to get your questions, and we love to discuss these topics with you.
Okay, thanks everyone.
Thanks everyone. See you soon.
Thank you.
Bye-bye.